It's an honor to be here today, and although I live in New York now, I'm actually the product of a large Midwestern research university. If anybody here is from the University of Kansas, I did both my undergrad and my graduate education at University of Kansas. Go Jayhawks. And it's actually really great that I'm going to be speaking right after Derek, because I'm actually going to be talking about wasps as custodians of data collections and using invasive insects to protect our data collections. I'm just kidding. My talk is going to be about a blog post I wrote last year, and I actually think it nestles, my discussion kind of nestles naturally between the things that Derek brought up about kind of the destruction and neglect of archives and the way we treat the information that we have, and then kind of Jill's conversation that's yet to come about data acquisition, because I'm also going to be talking about our data stream, but I'm going to be thinking, but I want to kind of frame it in the context of access issues in more of a kind of, I guess, contemplative and current landscape. So I think when most of us think about access of records in our collections, we're not necessarily thinking of neglect, which is something we definitely need to be cognizant of, but we're also thinking of where our access comes from, which in my mind leads us directly to thinking about our vendors and where we buy our information from nowadays. And vendors have become kind of the gatekeepers of a lot of our information, and I'm going to be talking about kind of that, the metamorphosis of our vendors, and how nowadays a lot of the records that we collect are linked to records that are actually being collected by government for surveillance purposes. And it's kind of almost the opposite of neglecting records. Instead, it's taking other records that might be unintentionally swept up in data packages and using them to surveil us and people like us in the United States, abroad, just more generally. So I'm a law librarian. I work at CUNY School of Law, and I teach both doctrine and skills. And I also work in the library. So I'm going to be focusing on legal products, but the things I'm talking about are kind of a microcosm of things that I think are happening for all of our vendors and all the places where we get all of our academic and research information. So I'm going to be focusing on LexisNexis and Westlaw. Is everybody familiar with those products? Okay, yeah. So, and they kind of exemplify common themes in all of our academic library vendor practices, and they were some of the first major publishers to embrace digital media. And now both products have huge online material collections, and those collections are relied upon by both legal academics and legal practitioners. I think it's pretty fair to say that without Lexis and Westlaw, I wouldn't be able to do my job, and most lawyers in the United States wouldn't be able to do their jobs the same way that they do now. So these products have expanded into other areas besides legal information, right? Now they do things like sell analytics packages, they are involved in risk management, and they're involved in cloud services. So not only do they do legal data and information work, they also do all this other work. And it's important to note that their expansions into these other areas are actually funded by our library subscription, right? For years and years and years, we give them, I mean, collectively billions of dollars, and they use this money to go out and buy different kinds of products and kind of expand their services horizontally into new marketplaces so that they can make more money, right? Along with kind of the other corporations that we're familiar with, data corporations are also evolving. They've changed a lot. I mean, even I've only been doing this for 15 years, and even in the 15 years that I've been doing it, Westlaw and Lexis are very different companies than they were. So I'm going to talk about some of the problematic aspects of these changes and these evolutions. And I wrote a blog post. Some people found it provocative. It was actually a censored blog post. If you Google my name and the word ICE, you can find the blog post, and I have a slide about it. It's the last slide. But if you want to see kind of what initially sparked this conversation, that's what did it. But I'm going to talk about the ways that the evolution of Westlaw and Lexis and other similar companies are kind of creating a gulf between the needs of academic clients like us and other clients, like those in the national security realm, in corporate sectors, in risk analytics companies, and law enforcement organizations, both governmental and kind of private eye type of companies. The latter seem to be having a huge influence on things like product design, content, and especially the services that the companies that we're used to using offer. So we're seeing things like restrictive terms of access, the collection and sale of personal data, greater non-transparency in the organizations that we depend on, and the merging of data and analytical services in a way that may be troubling for libraries and other library professionals. So it's a little bit of a change of pace, but I hope it's equally as relevant to thinking about our data chain and our supply chain. So this is actually just a screenshot from a recent article that was published online. And this article discussed the evolving nature of publishers. I believe, most of the resources that our patrons ask for and that we're kind of focused on collecting in our libraries are scholarly materials and journal materials. And this article talks about how what our publishers do and what our publishers are like is changing. Our smaller subject-specific journal publishers are being consumed by gigantic media conglomerates. So I think of it as kind of a Walmart analogy, where we used to deal directly with smaller subject matter dedicated publishers. We now deal with these huge corporations, and we've gone from kind of a corner store model for getting our data and information to kind of a superstore model, right? Nowadays in publishing, we don't get our journals one journal at a time. We don't go to each individual journal publisher and speak to them. Instead, it's kind of like we walk into a superstore and we have like a Costco-sized push cart, right? We have one of the big ones where you can fit a lot of boxes, a huge like tub of mayonnaise, just throw that in there. So and instead of buying one publication at a time, we buy bundles of publications, right? We can buy hundreds of publications just in a sweep, and we can opt in and out of these hundreds of different kind of data sets. And we buy them from the bundle by these huge companies that are also buying different kinds of bundles of information now, so that when you go and kind of look at the shelves of what's available to you, you have academic journals over here, but you also have analytic information over here and maybe personally identifiable information over here. And those are all sold by the same companies. The companies that this article focused on, if you're curious, are Reed Elsevier, Taylor and Francis, Wiley and Blackwell, Springer, and Sage. A precursor to future conversation. So these 5 publishers control 50% of all the journal articles that are published. So if you're publishing, chances are your article, no matter what journal it appears in, is going to be owned by Reed Elsevier, Taylor and Francis, Wiley Blackwell, Springer, or Sage. And these 5 companies are also companies that we all now depend upon, right? We need them in order to make our libraries function, in order to have what we need to make our libraries useful and fully productive parts of our academic communities. So I think that this shift in ownership of academic materials has also shifted the power structure of our libraries, and we are now kind of less in control than we once were, and we now have to contend with these gigantic corporations for our information instead of dealing one-on-one with journals, one-on-one with authors. It kind of creates more of a separation, a gulf between us and the materials that we ultimately provide to our patrons. So I wanted to kind of trace the roots of this metamorphosis, and because I am a law librarian and I'm focusing on Lexis and Westlaw, I'm going to do this by kind of showing the roots of Lexis and Westlaw. Now, I don't think these roots are that unique. I think most journals and most of our kind of data collection efforts have started out, as these modest, focused efforts and then grew into something much bigger. So Lexis, for instance, started out in 1968 in Dayton, Ohio, and their only goal was to gather up state and federal court decisions. So they wanted to take court opinions and make them electronically available. That was the goal of Mead Data Central, the company that later became Lexis. Soon after, West, who publishes all of those court reporters, so when you're watching any sort of lawyer TV show or court procedural, and there are those beige volumes behind those are court reporters. They're all published by West Publishing, and they contain court opinions, right? And they're chronologically listed in there. They're pretty, they look official, they make us look fancy as lawyers. So West publishes those, and when West saw what Lexis was up to, West said, oh wow, we've got to get in on this. And they also started creating an electronic collection of court opinions. And this started the natural, like, career-long competition between Westlaw and Lexis that I've always enjoyed as a law librarian. But they really cornered the market. They started before the internet was even a thing, and they made these really intricate systems. West incorporated their headnote system into their programming. Lexis bought Shepard's, which is a major court citator, and started doing a really nice job of creating a citator method so you could see whether the cases in their databases were still good law. And then Lexis followed suit, or Westlaw followed suit and created another citator. And now it's really hard to break into that market. They've cornered the system. They built these huge database systems that we pay collectively billions of dollars for every year as a legal profession, legal industry. And nobody else can really successfully enter the market. It's really expensive and time consuming to try to build legal research infrastructure. And a lot of the information is so complex that it can't be duplicated with ease. So full disclosure, I worked at Bloomberg LP for a time, and I actually tried to help them develop Bloomberg Law, a system to be a third participant in kind of this powerhouse. And really, I was amazed at how challenging creating a citator is, creating headnotes is. I'm not the premier expert, but I believe I am a legal research expert, and I don't see how anyone else could break into this market. So they have us where they want us, right? Westlaw and Lexis, we need them, they need us, and there's nothing we can do about it. We're entwined. So these companies did their thing, and eventually they were both bought up by larger companies, right? And you're probably familiar with both of these companies, right? We have our Reed Elsevier and our Thomson Reuters, and they own a lot of different types of data. So we became part of the legal data bundle in both of these companies. Both of these products are now owned by companies that invest and make other types of academic products. They both sell and bundle news articles and news materials, and they both also invest in and build surveillance products. Especially after 9/11, both Reed Elsevier and Thomson Reuters started picking up little kind of mom and pop surveillance shops, these kind of little private eye shops in different states across the nation, different localities, and started building big surveillance databases. These databases scrape and aggregate data from crime databases, credit databases, and other databases that collect personally identifiable information about all of us, about all of our patrons, about every person that they can possibly scoop information about. And that information, along with the legal databases and along with the news databases and along, LexisNexis Academic, everything we offer our students, they also bundle and sell surveillance data, and it's sold much like the legal information that we buy in our law libraries. The only real difference is the customer bases for these various data bundles, right? They have found ways to market to brand new customers, which is great for their bottom line. So I wanted to show this as an example. Have any of you ever used LexisNexis Academic or LexisNexis Legal? Yeah, it looks just like this, right? The login page looks identical, except for this is a LexisNexis page for a product called Risk Solutions. This is the product they market to law enforcement organizations like ICE. It's exactly the same interface. It has excellent searchability. Customer service is amazing. And it's designed to reduce crime, terrorism, and other cyber threats to make communities safer by doling out personally identifiable information to police forces. And this information, one of the reasons that Lexis and Westlaw are so kind of intertwined with this surveillance issue is Lexis and Westlaw consider this information to be legal information, law adjacent. So while their market base is law enforcement instead of legal practitioners, in their portfolio of goods, this is just a neighboring good to their LexisNexis databases that lawyers use. It's, to them, there's no ethical balance there. It's just more of a profit calculation and how will we categorize this with our other product bundles. So this is all well and good, and I think that policing is also an important role of government, and I didn't know anything about this issue until August of last year when I saw this article online. This article caught my attention a lot. A librarian posted it on the internet, not a law librarian, and said, hey, look, LexisNexis academics involved in this. And of course I clicked on the article, and that it shook me to my core. It got my attention. And it got my attention because Lexis was one of the organizations listed as one of the technology firms lining up to build the extreme vetting program that ICE is organizing. And this product is a cornerstone of my work, right? I use it all the time. I've taught hundreds and hundreds of students to use this product. Hundreds of legal practitioners know how to use Lexis because I made them experts at using Lexis. And a lot of legal practitioners I've trained are immigration attorneys, right? They'd want to know about this product. A lot of my students are dreamers. They'd want to know that I was teaching them how to use this. I began to wonder if teaching people how to use Lexis was a violation of my ethical obligations as a law librarian working in an educational institution. And that's what that blog post is about that I ended up writing. So before I get into what I was thinking about as I read this article, I wanted to explain the extreme vetting program and kind of briefly discuss what Lexis and Thomson Reuters were trying to get into. So I was going to start with explaining briefly what extreme vetting is. So ICE has been around for a really long time, and it's always been contentious, but it's become a much different agency recently than it was prior to 2017. So traditionally, ICE was established to ensure American security by preventing criminals from entering and staying in the country. However, in 2017, there was a sweeping executive order that was issued that really broadened ICE's focus. So initially, ICE was supposed to be focused only on serious threats. That was the scope of their duties, and that was the entirety of what ICE was allowed to focus on. However, the executive order shifted ICE's scope, making it much wider, saying that ICE could do whatever it was needed to do or whatever it felt it needed to do to preserve public order, which is much different than a serious threat. So it gave ICE a lot more room to try new things. Since the executive order was issued, there's been a 40% increase in ICE arrests in the United States. There's been a huge uptick in the amount of immigrants that are detained who don't have criminal convictions or who have criminal convictions like very minor traffic infractions and things like that. There have been horrific stories about children being removed from parents. And although asylum seekers are treated under a different program, the issues related to asylum have also been happening to just general non-immigrant communities. But asylum seekers have been denied humanitarian parole while their cases are decided, so they've just been languishing in detention centers. And there's really, I think the thing that's the greatest concern for librarians is that there's been a huge ramping up of surveillance in order to find more targets to kind of bring through this system and eventually lead to either deportation or self-deportation. So these types of practices are not traditional practices for our immigration officers. This kind of represents a change in what our immigration system is doing. And it's a different treatment of immigration generally than prior administrations. So I wanted to share also, this is a specific slide from that extreme vetting bidding day that they had. It's called an industry day. So the day where ICE invited all of these companies to learn more about the extreme vetting initiatives to help them create their bids and to help them craft the language of their bids, they gave a slideshow, ICE did. And this was one of the slides from the slideshow. And I chose this slide because it lays out the performance objectives, kind of the goals of the extreme vetting program. And notice number 2, the second goal is to create richer case files to support prosecution. And then the third goal, to create regular vetting and review for changes in risk profile. So to track various people and to review all of their data on a continuous basis in case there is a traffic infraction issued or something changes in their employment status. And all of this information would be supplied, by a Lexis or a Westlaw organization, or rather a Thomson Reuters or an RELX. So these surveillance programs give the agency a wealth of data to surveil, target, and ultimately detain and deport people using new practices that are widely viewed by immigration attorneys and courts to be problematic. And remember, this type of data, the type of data that they'll need to carry out these goals, are just another corporate information bundle, right, that Lexis and West market in order to raise their revenues. So here's just a partial list. The actual list of people who attended the Vendors Day was actually much longer than this, but I drew some arrows towards TRSS attendees and LLN SSI attendees, LexisNexis attendees. Those are all under the same umbrella as Westlaw and Lexis, the same companies that we spend thousands of dollars every year and market their services to our students, and we use in our daily practice. So, although nothing came of the extreme vetting program yet, I spoke with LexisNexis. They called me once their user metrics at my school started falling precipitously. They wanted to have a talk with me about maybe raising those metrics back up. And they wanted to ensure me that they hadn't bid on the extreme vetting contract because ICE hadn't yet put out the call for bids. So I asked them, they wanted to know what it would take for me to say positive things about them to my students. And I told them that, that I think it would make me and my colleagues feel more comfortable if they could put out some sort of statement promising that when that bid came open, they wouldn't bid on it, and that they wouldn't bid on any ICE surveillance contracts. And they said they would get right on it. I'm still waiting. I'm hopeful, I'm an optimist. I told them the second that they got me that statement, I would share it with every librarian I knew. I would share it widely, and I would praise their social responsibility. So while I was doing all of this, feeling bad about Lexis, Thomson Reuters went ahead and quietly signed numerous contracts with ICE in January and February. This is an example of a contract that didn't go through a bidding process. They just went ahead and bypassed the bidding process and sole sourced it to Thomson Reuters. And this contract was signed on February 7th, despite the fact that Westlaw had promised that they weren't going to sign any contracts with ICE. They sent, the person who wrote this article forwarded me an email, or somebody associated with that article forwarded me an email that they'd gotten from the head of marketing services from Thomson Reuters saying they would not engage in ICE contracts. Apparently, they had a change of heart. I'm sure it was probably financially driven. Maybe I'm being too cynical. But they did sign this contract with ICE. And I pulled out two specific provisions. So the first clause is an overview of what ICE plans to use the material for, right? The data that they're buying from Thomson. So they're going to use it for the arrest, detention, and removal of criminal aliens. Remember, a crime can be a traffic infraction, and it does not have to be a convicted crime at this point, apparently, from what I have read. So they're going to use this data to arrest, detain, and remove undocumented immigrants. And I think that the second clause is more concerning because it lists the direct types of data that Thomson Reuters has promised contractually to supply to ICE. So I'm just going to read it off for you because it sounds so impressive. So they're going to give the following specified data types to ICE. They're going to give FBI numbers, state identification numbers, real-time jail booking data, credit history, insurance claims, phone number account information, wireless telephone accounts, wire transfer data, driver's license information, vehicle registration information, property information, payday loan information, public court records, incarceration data, employment address data, individual taxpayer identification data, and employment records. Just a couple pieces of data. So would you be comfortable with the government tracking all of this data about you on an ongoing basis in order to vet you for possible sanctions? Does that make you? No, that's not a good feeling. But Thomson Reuters, as part of their data provisions, is going to hand that information over to us, or to ICE, on an ongoing basis pursuant to this contract. What's more, ICE signed a separate contract with West Publishing to provide license plate databases. And the reason that this is a concern is because ICE actually tried to start this program in 2014 to collect this type of data, and there was a privacy impact assessment that was done that actually showed that collecting this type of data violates our privacy norms and policies as the United States government, and they weren't allowed to have this type of data back in 2014, but now under the new administration they are. So why are our vendors getting involved in all this information collection? And it's largely, profit. And it's because they don't just do academic information anymore. They've changed, right? They've morphed into and been purchased by these huge transnational corporations. And now the academic data is just one of many bundles of data that our publishers create, send, profit from. And this is part of a larger publishing trend. What does this mean for libraries? Well, there's no more mom and pop shops, right? Collection development involves these huge data corporations necessarily, so we have to learn how to maneuver in that environment. And we're also no longer the top priority clients, right? We're the academic libraries, but now they also have ICE as a client, they have law enforcement agencies as a client, they have corporate vendors as clients who repackage information for other reasons. And there's no longer a complete understanding of how vendor practices work. Our vendors now do work outside of libraries that we don't necessarily understand and we don't necessarily have access to. There's no more academic publishers also. We have information conglomerates rather than our own academic products. So we have to reframe our understanding of who and what we're dealing with. And these are some of the questions that I think are opened by this change. I think it's probably a good time for us to wonder if our ethical duties are still the same as they were before these changes happened. The last slide I'm going to show you is actually a quote from the ALA's Code of Ethics. But what does it mean for our privacy ethics? And what does it mean from a critical information literacy standpoint, right? What does all of this say about where our data comes from? And I also think that it kind of goes back circular to what Derek said about democratizing information and about how we can rethink our data collection and access systems in order to kind of avoid these types of pitfalls, right? Along with the pitfalls of data destruction and data neglect, we have other ethical pitfalls that we should now be considering. So I want to close with a quote from our ethical code that I think we all probably learned when we were, getting our degrees in library sciences or information science. We protect each library user's right to privacy and confidentiality with respect to information sought or received and resources consulted, borrowed, acquired, or transmitted. What does this mean to us in an era when our vendors have dramatically changed the services that they provide, not just to us, but to others? So yeah, I think that's the question I would open to all of you. And unfortunately, I don't come with solutions. I only come here today with kind of provocative issues and questions. And if anybody's curious about the blog post, the blog post got stripped from the AALL website, but it eventually found a home on Law Librarian blog. So if you want to read it, that's where it is. Thanks.
Actually, more of a context question. Particularly in the areas of business and legal research, the academic libraries have never been the primary market for these databases. To assume that we had the say or influence from the beginning just was not really a reality. So I'm wondering how that plays into your thought process, and when it comes to ethical obligations, are we more ethically obliged to make sure that our students are graduating with the tools that are going to be in the marketplace versus our intellectual, professional, ethical duties? So to me, there's also that balance, but with Lexis or Factiva or Wall Street, Dow Jones, we've only been a very minuscule slice of their financial reward because the marketplace is there. We've got these databases because of our students needing this kind of access. So I think I'm actually viewing this as being very different than presenting it that we lost our say with these corporations, because we've never had our say with these corporations.
Yeah, I think that that's a good point. And that's actually, one of the first conundrums I fell into as somebody who's thinking about this problem. I have a duty to make sure that I teach law students who can go out and practice law effectively. And so it is part of my duty to teach Lexis and Westlaw and to do so effectively. And it's hard for me as a law librarian to balance that. And I also do agree with the question of whether we are at all empowered or should be as academic research institutions, when it's true there's this huge private market for Lexis and Westlaw that may, have more of a financial buy-in than we do, and that may be more the central customers. And I think that's largely a choice that goes back to what we do about this, right? What do we think about this, and how does our ethical code, how much does that weigh into how we manage the products that we use? So we could decide as professionals and as teachers that it's more important to arm our students with knowledge about how to use Lexis and Westlaw. But I also do feel like all of us individually as librarians and librarian institutions don't have that much power as people who, may try to encourage social responsibility in our vendors. But I think that organizations like CRL, like ALA, like AALL, our professional organizations may have a little bit more clout, especially if we are vigilant about privacy ethics and calling out instances where privacy ethics aren't being followed in our vendors, if that's a road we're interested in taking. Yeah.
This is a very interesting presentation. I share concern about how our privacy is being picked up, and many, aside from the institutions or companies you talked about, in other social media companies and so forth. I get that. However, it seems to me a part of your theme, though, is suggesting a bit of censorship or who has rights to use information as they want. And that troubles me a little bit, that we, you, or whomever is saying how they can use that information. And so anyway, can you address that? That
Yeah.
part of your talk troubles me, I guess.
I'm sorry, I don't, but it's a troubling topic, and it doesn't have a clear answer. And I agree. I also, would be concerned with censorship in any respect, or trying to direct the way information is used. And there was something else the first part of your question, which of course I've now forgotten what I was going to say. I'll remember as soon as I step away. But yeah, I think that I'm not sure. Like I said, I'm presenting what I see as, one potential problem. I don't know. I don't know what the solutions are, and obviously I think that this is a small microcosm that's also being reflected in, say, the Cambridge Analytica issue, and the way that we're all aware that when we engage in social media, we also give pieces of our information out, and who gets to use that information, and how do we control that? So I think that this is just another way in which we've kind of opened this Pandora's box of marketing personally identifiable information. I guess, if anything, at the very least, this would show that our academic products aren't free from the same kind of behaviors that we're seeing going on in social media and that we're seeing going on in the internet generally.
But haven't all of our library resources been used for who knows what? As librarians, are we to judge how you use that data and that information and say this is right or wrong.
Well-
I get the code of ethic that you have on there, but it seems that there is an aspect of librarianship also that says that we're not censoring that or the use of that.
Sure, sure. I believe that librarians stand up strongly against censorship, but I also know that librarians have been willing to go to jail to protect the personal information of their patrons. We protect people's private information. We believe in the censorship, in the lack of censorship of public information, but the information about people, now that I mean, unarguably, librarians and the ALA have taken a very strong stance about protecting. And I believe that the information that's being collected by these entities is much more like the information of our patrons, if not the exact same thing. So I do think that there's an interesting question there, but I do think that the line between censorship and privacy is one that librarians, especially in this day and age, have to be very, very careful about protecting and honoring. Thank you.